Good morning and good afternoon, ladies and gentlemen, wherever you're joining us from. My name is Sue Ann, SIAC's Manager Legal, Strategy and Development, and I'm pleased to be your MC for today's SIAC-MIAC webinar titled Expedited Procedures, Perspectives from Singapore and Spain. At the start of the webinar, SIAC and the Madrid International Arbitration Center, MIAC, will be holding a virtual MOU signing ceremony. We will now begin the virtual signing ceremony of the MOU between SIAC and MIAC. With us are Ms. Gloria Lim, CEO of SIAC, and Mr. Jose Antonio Caenzos Fernandez, President of MIAC, who will be signing the MOU on behalf of their respective institutions. We would now like to invite Ms. Gloria Lim to deliver her welcome remarks. Ms. Lim, please.
Thank you, Sue Ann, for the introduction. Mr. Jose Antonio Caenzos, President of the Madrid International Arbitration Center, our distinguished panel, ladies and gentlemen, a very good afternoon, morning, and evening to everyone, wherever you are in the world. Thank you very much for taking the time to join us today for the SIAC-MIAC webinar and Memorandum of Understanding signing ceremony. SIAC is very delighted to be entering into this Memorandum of Understanding with MIAC to jointly promote and develop international arbitration as the preferred mode of dispute resolution for cross-border commercial disputes involving Spanish companies and businesses. Under the MOU, SIAC and MIAC will collaborate to jointly organize in-person, hybrid, and virtual conferences, seminars, and workshops on international arbitration in Singapore and Spain, as well as invite key members of our local arbitration communities to attend and participate in major events organized by SIAC in Spain or by MIAC in Singapore. In terms of services, upon request, both institutions will provide recommendations of arbitrators to each other and also conduct training programs with each other's staff. The terms of the MOU also contemplate that we will collaborate on facilitating requests on preferential rates for hearing facilities involving Madrid-seated and Singapore-seated arbitration hearings at Maxwell Chambers in Singapore and Madrid's founding courts, respectively. We hope that through this collaboration, SIAC and MIAC can encourage greater exchanges and user education in the area of international arbitration and strengthen the provision of efficient, expert, and enforceable international dispute resolution services to parties from Spain and Singapore. We are excited and we look forward to future collaboration opportunities with MIAC. To those of you who may be less familiar with SIAC, I would like to take this opportunity to share some of the recent trends and developments here. SIAC is headquartered in Singapore with representative offices in China, India, Korea, and the United States of America. In the Queen Mary University of London International Arbitration Survey, released in May 2021, Singapore jointly ranked with London as the most populous seat in the world and was the most preferred seat in the Asia Pacific. SIAC ranked as the most preferred arbitral institution in the Asia Pacific and was second among the world's top 5 arbitral institutions. SIAC celebrated our 30th anniversary last year. Over the years, SIAC has experienced growth, particularly in terms of our international caseload and the diversity of parties arbitrating at SIAC. Just last week, we announced our 2021 case statistics. In 2021, we saw our third highest caseload with 469 new cases and the total sum in dispute totaling US dollars 6.54 billion. Users continued to entrust SIAC with high-value cases, and the highest sum in dispute for a single administered case for 2021 was US dollars 1.95 billion, which was more than twice the highest sum in dispute in 2020. 86% of our cases were international in nature and comprised parties from 64 jurisdictions, including Spain. The procedures under the SIAC Rules 2016 continued to be well received by users, with an increase in the number of applications for the expedited procedure, early dismissal, and joinder from 2020. Turning to today's panel discussion, our distinguished panel will be speaking on the expedited procedure. The expedited procedure is one of SIAC's most popular procedures among users. In 2021, SIAC crossed 700 expedited procedure applications since the procedure was first introduced in 2010. As of 8th of April 2022, SIAC has received a total of 740 applications and granted 412 applications. Our distinguished panel will be sharing their insights and perspectives from Singapore and Spain on this procedure shortly, and I'm looking forward to hearing what they have to share with us. On behalf of SIAC, I would like to thank our MOU partner, MIAC, Mr. Jose Antonio Caenzos, the president of MIAC, and Mr. Victor Gamero Cabo for working together with us on today's event, which I would consider to be our very first collaboration under the MOU. My heartfelt appreciation as well to our panelists and to all our guests online and participants for spending time to be here with us. Thank you once again to everyone, and I look forward to an engaging session.
Thank you very much, Ms. Lim. We would now like to invite Mr. Fernandez to deliver his welcome remarks. Mr. Fernandez, please.
Thank you, Sue. Good afternoon, good morning, everyone. It's a great pleasure to be here with you. Thank you, Gloria. Thank you, all the team that has been working for preparing this ceremony and this seminar. It's a great pleasure for the Madrid International Arbitration Center, for MIAC, to meet with the Singapore International Arbitration Center for the signing of this collaboration agreement between the two institutions. MIAC is an institution born in Spain for the administration of international arbitration and mediation cases with a global vocation. Its 4 working languages, Spanish, English, Portuguese, and French, and the presence of experts from more than 25 countries in its governing bodies, Commission for the Appointment of Arbitrators and Mediators, prior scrutiny of awards, and international arbitration commissions, are some of its characteristic features that demonstrate this. One of MIAC's strategic lines is the growth of international arbitration in Spanish, as a language with almost 600 million speakers worldwide and a growing presence that goes beyond Spain and Latin America to spread throughout Europe and United States of America, but which is also receiving greater interest in Asia and Africa. Spain's vocation as a bridge between continents, due to its location in Europe and its strong links with America, is a characteristic that also leads us to think of Asia as the region with the greatest development in alternative dispute resolution formulas in recent decades. In Asia, we see Singapore in particular as an example of good practice that has allowed this country to be at the forefront of international arbitration and mediation in just a few years. The SIAC, for its part, is already a benchmark in international arbitration. Its rules are considered to be one of the most easily adaptable to the needs of users. SIAC and MIAC agree that their activity is not limited to the administration of arbitration cases, but also extends to the organization of events that provide information and training to those interested in this field. MIAC is convinced that the joint work of the most representative arbitral institutions of international arbitration that share principles such as excellence in user service, the highest ethical standards, transparency, diversity, sustainability, the desire to be at the forefront of the changes that are taking place in the management of arbitration, is a task that benefits everyone. For MIAC, the signing of this agreement is a milestone because we are convinced that we are going to carry out joint tasks in the future that will be useful for both institutions and for the users of arbitration. The seminar we are holding today is a good example. Expedited procedures are a reality that has improved the service to the users, and SIAC's contribution in this sense is very important. Nowadays, nobody disputes the usefulness of expedited procedures because without losing the basic features of arbitration that guarantee the right of defense of the parties, they make it possible to respond to one of the most frequent requests from users, the need to save time and costs. The fast-track procedures, which have had a great success all over the world, have shown that imaginative and flexible formulas must be sought to adapt to the changing needs of international trade. MIAC has a fast-track procedure in its rules of procedure and has already dealt with a number of cases under this procedure. The outcome is positive, and it is MIAC's intention to make some changes that will make it increasingly attractive to potential users. We have no doubt that cases with lower amounts deserve the same attention as big cases, and that only if we demonstrate to the market that we are able to offer a good procedure for them, the best arbitrators and reasonable costs, we will succeed in our main objective, which is the promotion of arbitration as a method of dispute resolution. This change of experiences between SIAC and MIAC is the aim of this seminar, which we hope will be the first fruit of a long and fruitful collaboration for all. Thank you very much.
Thank you very much, Mr. Fernandez. Ms. Lim and Mr. Fernandez will now each sign a copy of the MOU. Can we also take a quick photo?
Sure.
Thank you. On my count in 3, 2, 1. Thank you very much.
Thank you.
Thank you once again, Ms. Lim and Mr. Fernandez. That concludes the virtual MOU signing ceremony. We will now begin the panel discussion on expedited procedures, perspectives from Singapore and Spain. Our panelists are Mr. Victor Gamero Cabo, partner of Gamero and Bravo Abogados, Mr. Ng Kim Beng, partner of Raja and Tan Singapore LLP, Dr. Manuel Pinades, senior lecturer of King's College London and independent arbitrator, Ms. Joy Tan, partner of Wong Partnership LLP. Moderating this session is Mr. Lawrence Day, senior partner and global co-head of Denton's International Arbitration Group. I will now pass the time to Mr. Day.
Thank you, Suen, and welcome everyone to the SIAC-MIAC webinar, Expedited Procedures, Perspectives from Singapore and Spain. The idea of a fast-track arbitration for lower value or less complex disputes has been a popular one, with arbitral institutions around the world introducing expedited procedures that contemplate the completion of the entire arbitral process within an abbreviated period of time. As you've heard, SIAC itself has seen more than 700 applications since it offered an expedited procedure. However, the requirements that must be satisfied differ from institution to institution, and the perspectives of the claimant, the respondent, the tribunal, and the institution bring different considerations to the process. With us today to discuss expedited procedure arbitration are Mr. Victor Gamero Cabo, partner, Gamero and Bravo Abogados. Victor is qualified in Spain and focuses on international commercial arbitration and in particular on construction, trade, transport, and hospitality disputes. Dr. Manuel Pinades, senior lecturer, King's College London. Manuel researches and teaches international commercial law and has written about the relationship between arbitration and cross-border insolvency. He's a consultant expert witness, and an independent arbitrator. Third, Ms. Joy Tan, partner, Wong Partnership. Joy is joint head of the commercial and corporate dispute practice of her firm and focuses on banking, corporate, and commercial dispute resolution. She is an SIAC arbitrator. Last but not least, Mr. Ng Kim Beng, partner, Raja & Tan, Singapore. Kim Beng is joint deputy managing partner of his firm and has had many years of experience as counsel in international arbitration and in particular in construction disputes. I'd like to take the panel to the first part of this webinar, which is to explore and compare expedited procedure in SIAC and MIAC. The SIAC and MIAC rules have in common the idea that if the parties agree specifically to an expedited procedure applying to the resolution of their dispute, then the amount of the dispute is irrelevant. However, they also differ in some ways. And I'd like to ask Kim Beng, first of all, if he could tell us briefly about the SIAC procedure of a party applying for proceedings to be conducted according to the expedited procedure. Kim Beng?
Thank you very much, Lawrence. Under the SIAC rules, the arbitration process is initiated with the filing of the notice of arbitration. What is prescribed that should be included, information included in the notice of arbitration, aside from the formal particulars of the parties as well as the legal representatives, is a brief statement of the nature and circumstances giving rise to the claim, a description of the reliefs sought, and as far as possible, a quantification of the reliefs claimed. What then follows after the notice of arbitration is filed with the registrar and a copy served on the respondent is that the respondent is invited to provide its response to the notice of arbitration within 14 days. Now that response would also be setting out the formal particulars of the representatives and the parties. It would state some brief responses to the statements in the notice of arbitration, and as well as provide a brief statement on the nature and circumstances of any counterclaim, including a quantification of the counterclaim. What then ensues after this exchange is the identification of the panelists, or rather the arbitrators who will be empaneled to the tribunal. And that process culminates in the constitution of the tribunal. I've taken everyone through that process because under Rule 5 of the SIAC rules, the parties are allowed to apply for expedited procedure prior to the constitution of the tribunal. And there are a number of criteria to be satisfied for the application to be made. One of them is that the threshold amount, or rather the amount in dispute, should not exceed Singapore $6 million, or about slightly under $4.5 million US. The amount is an aggregate of what is claimed under the notice of arbitration, what is in the counterclaim, as well as any set-off that is claimed by way of defense. So with that criteria in mind, one can understand why the timing that is set for the application to be made, i.e. before the constitution of the tribunal, is such, because it necessarily has to be the case that you would only know, or one can only know what the amount in dispute aggregates to after we see the response to the notice of arbitration. But that's not the only criteria that applies. There are two other criteria, and all can be satisfied in the alternative. The second is if there is an agreement between the parties for the expedited procedure to apply. Now that agreement can either be contained in the contract between the parties, or it can be separately entered into between the parties even after the dispute has erupted. The SIAC, incidentally, I think on its website, provides a model provision that parties who are desirous of including that agreement to refer disputes to the expedited procedure process incorporated in their contract. It actually provides the model language for that. The third criteria is that of exceptional urgency. And commentators have observed or have opined that that usually refers to, it depends on the facts and circumstances of the particular case. I would venture to say that considerations that would generally apply would be the financial status of the parties, the arbitrants, as well as whether there's any risk of dissipation of assets. Now, even after the criteria is satisfied, it doesn't mean that the arbitration will automatically be conducted in accordance with the expedited procedure. The president of the Court of Arbitration of the SIAC will make that determination after consulting the parties, as well as having regard to all the circumstances of the case. And if the president so decides, the registrar will then notify the parties that that is the case. For observant listeners who heard the opening address by SIAC CEO Ms. Gloria Lim earlier, I think the statistic is that more than half of the applications for expedited procedure are accepted. So that's an interesting statistic to note. And with that, I will hand the time back over to you, Lawrence.
Thank you, Kim Beng. Victor, MIAC procedure is slightly different and refers to an automatic application of the expedited procedure in some cases. Could you explain it briefly to us?
Thank you very much for your kind introduction, Sue and Lawrence. It is a real pleasure to be with all of you today. I'm happy to share my thoughts regarding expedited procedure. But please, before moving right to the questions, allow me to congratulate SIAC and MIAC on the MOU signing, which we hope is just the beginning of a fruitful and long-standing collaboration between the two institutions. So moving back to the MIAC rules, these rules were released in 2020 together with the inauguration of the center, and they are based on the Spanish arbitration club model rules, which are a recommendation of its code of best practices in arbitration. And these rules regulate the expedited procedure in Article 57. And the first thing I think we should know is that MIAC adopted an opt-out approach, which basically means that the expedited procedure will be applied automatically when some criteria is met. According to this Article 57, this criteria is going to be met when first the total quantum of the dispute, it is equal to or less than €1 million, taking into account the claim, any eventual counterclaim, set of claims, and the number of parties to the arbitration. And second, that the parties have not expressly agreed on its non-application in the arbitration agreement. These two requirements are cumulative requirements. So for the expedited procedure to be applied automatically, they have to be met. It is also important to note that under MIAC rules, expedited procedures will be also conducted if so agreed between the parties, regardless of the date of the arbitration agreement, and more importantly, regardless of the quantum of the dispute. So if we have, as you well said, Lawrence, an €8 million dispute, and the parties agree on having their dispute conducted as an EP, it will be conducted in such a manner. The Article 57 also regulates the possible objections of the parties to the expedited procedure. And if that is the case, if they file it, these objections have to be included in the request for arbitration or in the response to the request for arbitration. These objections filed by the parties will be ruled by the center after having heard the other parties of the arbitration. Another element here that we should highlight is that irrespective of the provisions we've mentioned, expedited procedures will not be conducted if so determined by the center having regard to special circumstances of the case. So in this way, we have at least to remember two mechanisms. One for the parties to be able to agree on the application of the expedited procedure, regardless of the quantum of the dispute, and at the same time, a control mechanism for the center to avoid expedited procedure in special cases. So the first conclusion I think we can draw here is that SIAC adopted an opt-in approach, which has a slight preference for parties' autonomy, and MIAC adopted an opt-out approach, which tends to favor a little bit efficiency of the proceedings. So just to conclude, Lawrence, this substantial difference is not only seen comparing these rules. Indeed, arbitration centers are quite divided in how to regulate this aspect. And in my view, this is just a good example of the difficulties that centers face in trying to find a proper balance between the parties' autonomies, efficiency, and respect for due process, which is a really hard task to accomplish. And I get back to you.
Thank you. An interesting take on different ways in which to approach this general concept that lower value claims or less complex claims should be dealt with expeditiously. I'm going to ask Joy now whether she has any observations on similarities or differences between the SIAC and MIAC procedure, or indeed any general observations on procedure. Joy?
Thank you very much, Lawrence. And can I also add my congratulations to SIAC and MIAC on this momentous occasion. Just a very quick one from me from the Singapore perspective. In Singapore, as we've seen, under SIAC Rule 5.2b, for an expedited procedure, the requirement is that the case will be referred to a sole arbitrator unless our president, the SIAC president, determines otherwise. In addition, SIAC Rule 5.3, which was added in 2016, goes on to specifically state that by agreeing to arbitration under the SIAC rules, parties also agree that when the EP is ordered, procedures in 5.2 shall apply, even where the arbitration agreement contains contrary terms, right? This provision stems from a 2015 Singapore case that I think Lawrence, our moderator, argued, the case of AQZ, which involved an award that was made under an EP before a single arbitrator, right? And then there was then a set aside application to the court under the Model Law 34.2A4 on the ground that the sole arbitrator appointment was not in accordance with parties' agreement because of the provision of the arbitration agreement for 3 arbitrators, right? The Singapore court rejected the argument. It held that a commercially sensible approach was to recognize that the SIAC president had a discretion to appoint a sole arbitrator under the expedited procedure in the interest of saving time and cost and efficiency. And in that instance, the court held that the president had exercised his discretion properly in this case, and because there was no prejudice to the parties, therefore the appointment of a sole arbitrator under the expedited procedure was to override parties' agreement to have 3 arbitrators, right? Of course, we do recognize this might be seen as somewhat detracting from party autonomy, and you know, we recognize that there is I think a Shanghai Intermediate Court decision, you know, that goes the other way, right? But at any rate, the position in Singapore, you know, thanks to the SIAC Rule 5.3, it's now beyond doubt, right? You refer to a single arbitrator under the expedited procedure, that's going to override any specific provision for 3 arbitrators or indeed any different position in the arbitration agreement. That's a feature of the Singapore expedited procedure. I'm not sure if this finds any resonance on the MIAC side or indeed in Spain.
Thank you, Joy. Manuel, a moment ago, Kim Bing referred to a party's financial position as being possibly a factor that could go towards an exceptional urgency that may make an expedited procedure apply. Now, I know from speaking with you that you have articulated a view that if a party is in financial difficulty, that might indeed be a situation in which an expedited procedure can and should apply. Would you like to speak to that a little bit more?
Sure. Thank you for the question. it is indeed a possible factor that when a party is in financial difficulties, let alone on formal insolvency proceedings, it might make little sense to embark on costly and lengthy arbitration proceedings. So in that sense, from the point of view of rules like SIAC, where the president has to make the ultimate decision as to whether expedited proceedings are accepted or not, the financial circumstances of parties will be a very relevant factor. The approach, however, is different in the MIAC rules, given that the system is an automatic application of expedited proceedings, and therefore financial considerations are not a relevant criteria. If at all, it's a relevant criteria for the center not to exercise the power, not to allow expedited proceedings and impose, so to speak, ordinary proceedings, although I am pretty sure that MIAC Center will respect the agreement of the parties. A completely different question, however, is whether institutions would want to consider, from a regulatory point of view, including a rule in the future where the financial circumstances of a party is a relevant factor, one of the thresholds or the criteria to apply for expedited proceedings, or even more complex, to change the nature of the proceedings once they are pending. That is, to move from ordinary to abbreviated or expedited proceedings, precisely to alleviate the financial constraints posed by arbitration, and therefore maybe facilitate that insolvency courts see arbitration as an insolvency-friendly procedure, as opposed to as a mechanism to use assets and resources which could be dedicated to the recovery of the insolvent party. And just very briefly on the point that Joy made on whether the MIAC rules have any resonance on the rules of SIAC on one arbitrator only, that is indeed the case. Expedited arbitrations and the MIAC rules will have one arbitrator regardless of the agreement of the parties. And I will just simply say that the courts of Spain last year, in a setting aside action, confirmed that the application of the one arbitrator rule, even in cases when the parties had agreed on a 3-member tribunal in their agreement, did not violate party autonomy and did not amount to a conduction of proceedings in disregard of the parties' agreement. So that goes along the lines of the Singaporean approach, as well as Rule 5.3. So it's good to see that we are both in the same direction.
Good, thank you. Let's now move on to the usual practice directions, if we can even call it that, that are made in expedited procedure. The SIAC and MIAC rules both contemplate the completion of arbitral proceedings within a relatively short space of time, and both involve the possibility that ordinary timelines could be abbreviated, cut short. Joy, could you tell us from your experience what kinds of directions parties can expect to be given by tribunals in SIAC expedited proceedings?
Thank you, Lawrence. So, as we know, SIAC Rule 5.2 sets out various expedited directions that may be expected by parties under the expedited procedure. I think for one, time limits under the rules may be abbreviated. And for the second, we've been talking about the appointment of a sole arbitrator as the general position. Yeah. There are 3 other aspects that are provided under 5.2. The tribunal may dispense with an oral hearing and proceed on a documents-only basis. The final award, there is a deadline. So the requirement is that your final award needs to be made within 6 months of the tribunal being constituted. And finally, the tribunal is permitted to state its reasons in the final award in a summary form. So let me make a few points in terms of what parties can expect under the procedural order number 1 for an expedited procedure, right? I think the first point to make is that tribunals will typically give very short timelines of 2 to 3 weeks for statements of claim and defense. And also they'll typically order that these will be accompanied by all the supporting documentary evidence and often authorities that are relied on by the parties, right? So these timelines will typically factor in, or they'll work backwards from the 6-month deadline that we've been talking about, right? And just to note regarding that deadline, it may be extended, but only in exceptional circumstances, right? So your tribunal will have this in mind when handing down the timelines for the statements. These timelines should also factor in time for SIAC scrutiny. At the SIAC, there is a robust scrutiny process, which will typically, in the expedited procedure space, take about 1 to 2 weeks, right? So they work backwards from that. I'll say parties can also expect strict consequences if these timelines are not adhered to. So, you know, if you don't adhere to the timeline, there is often an order that, you know, the contents of the statement gets disregarded, right? Lastly, I think Kim Beng is going to speak about this a little, but in terms of, you know, interlocutory applications and document production and so forth, you know, your typical PO number 1 will exclude such matters or will provide very, very short, limited basis for making those sorts of orders, right? So that's your procedural order number 1. Turning to you know, this issue of proceeding on documents only and dispensing with the oral hearing. Under the EP, the tribunal is empowered to do that, provided that it consults with the parties, right? So this does mean that in an appropriate EP case, it would be possible for the tribunal to go in the documents only way, even if one party agrees, doesn't agree and insists on an oral hearing, right? But of course, in the face of such party objection, tribunals are usually slow to dispense entirely with the oral hearing and with witness cross, you know, because of concerns, right, about, you know, due process and natural justice and so on. I mean, I will say I took a straw poll around my firm, and we could only come up with one documents only case where there was no explicit agreement between the parties, right? And I think that just, you know, in this regard, we are all mindful of a recent Singapore case of CBS, right? And in that case, the Singapore court set aside an award made under the Charter of Maritime Arbitration rules that was on a documents only basis. And in that instance, the respondent had asked for an oral hearing, right? Now, of course, that case did turn specifically on the SCMA rules, which there was no explicit power to proceed on a documents only basis, you know, without consent. I mean, unlike the more flexible SIAC rules. But, you know, however, I think that's a cautionary tale for tribunals to, you know, usually default to the position that's expounded by our Court of Appeal that, you know, natural justice must not be sacrificed in the name of efficacy, right? I'll say, you know, when just before I leave this point, that, you know, even if cross and oral submissions are ordered, you know, parties would expect tribunals to set very tight timelines for that. You know, a one-day hearing, maximum of one-day hearing is the norm. Just a last point in terms of the length of the award. Tribunals, as we've said, right, they're permitted to state reasons in a summary form. Of course, the challenge there for tribunals is how to strike the balance between sufficiency and brevity. We take guidance from the Singapore court case in TMM division. And in that case, the court found that the crux was whether the contents of the award, taken as a whole, inform parties of the bases on which the tribunal reached its decision on material or essential issues, right? So the case stands for the proposition that even if some of the conclusions are devoid of reasons, that's not necessarily fatal. Yeah, the test is whether the award explains the final outcome on material issues, looking at it as a whole and not at each and every issue. In terms of what parties can expect, I'm in my experience, and I'm also told pursuant to this other straw poll, that awards made under the EP are usually about 30 to your maximum 50 pages, which is significantly shorter than ordinary awards that are usually, well, often over 100 pages. So, you know, parties can expect to receive a much shorter award, but they also would expect to receive a reasoned award. Thank you, Lawrence.
Well, MIAC expedited procedure refers specifically to the ability of the tribunal to limit the number extent and scope of witness statements. And this could be of interest to the audience. Could you tell us more about that and other aspects of MIAC expedited procedure, please?
Sure. Thank you for the question. So Joy made it very clear that expedited arbitration requires a hands-on approach. Arbitrators cannot adopt a passive role and let the parties run the show, but much to the contrary. And for that reason, I find it very positive that the MIAC rules provide that a conference shall be held within 20 days after the case file is sent to the arbitral tribunal in order to discuss the efficient organization of the proceedings. So after 20 days, ideally, the agenda should be set between the parties and the tribunal. And that ideally will be followed by an early set of directions or a PO1, which as arbitrator, I find very useful, not only to clarify that procedural sequence to the proceedings, but also to avoid future attempts to derail the arbitration for reasons which were known to the parties or should have been known to the parties at the time the PO1 was issued by the arbitrator. And I should also point out that at that stage, I have found it very useful to have the institution on my side. I think the institutions play a relevant role, and I'm sure that both SIAC and MIAC adopt the same position. They know the case very well, they monitor its progression, and they provide much support throughout the process. And so a relevant idea derives from this, which is that expedited arbitration is not of less quality, it's not less fair than ordinary arbitration. Frequently, in fact, expedited arbitration is just excellent value for money. And that's something that parties really value. And that's also one of the reasons why I'm sure expedited arbitration has been one of the most successful products that SIAC offers to the very competitive arbitration market. But in order to deliver precisely that value, the overarching challenge for the tribunal and also for the institution is to finally balance the need for efficient and cost-effective dispute resolution procedures with the respect of the parties' right to due process. And that can prove problematic, as Lawrence just mentioned, when arbitrators need to exercise their case management powers precisely on the decision of an oral hearing or the use of written statements. And I want to phrase it that way: the power of the arbitrators is a power that derives from the rules that parties have selected. And that's why the exercise of this organizational discretion by the tribunal should not be seen as a departure from the parties' agreement, but much to the contrary, in my view, as an implementation of their agreement. Now, expedited arbitrator, therefore, requires confident arbitrators who can exercise those case management powers with a resolve to act assertively in procedural matters at the earliest stage, precisely to promote the efficiency that parties want to achieve. Now, as to oral hearings, they are indeed still the rule even within expedited arbitration, precisely because parties choose arbitration, among other reasons, to have that depth and type of hearing which they might be unable to obtain in court. And in my experience, even a short hearing in person or these days online might offer the arbitrator and the parties a level of understanding and feel about the case that sometimes document-only procedures might not be able to provide. That does not mean, however, that document-style expedited arbitration is unacceptable or deprives parties of the right to due process. In the end, it will be a decision dependent on the type of evidence relied upon by the parties. Clearly, expert witnesses or fact witnesses will be more eligible for an online hearing, for a hearing than a document-only case. And it will also depend on the length of the steps prior to the hearing. And that links to the question, Lawrence, that you were making, which is the use of written statements. I believe that in expedited arbitration, one round of submissions, maybe followed by a brief hearing, might be much more preferable than 2 rounds of submissions by parties, which will eat up the time that could be used for a hearing. And the same even logic could potentially apply to witness statements. Might be better to not have written witness statements in exchange of having an oral hearing where those statements can be cross-examined by parties and the arbitrators. And that was indeed my experience as arbitrator recently in an expedited case, and that worked really well. I provided for a 1-day hearing dedicated exclusively to the examination of witnesses using a chess clock method, and then I followed that with written submissions or written conclusions by the parties limited to 20 pages per party. Now, very briefly to conclude on that, Joy has already mentioned that the scrutiny of awards, which we both MIAC and SIAC offer, unlike other institutions, and I believe is an additional value, is included in that time limit. Now, importantly, there's no time limit set expressly in the rules. It is for the center to reduce the time within which the arbitrator, the award has to be issued. Although it is my understanding that this might be now subject to review by MIAC precisely to include an express reference to a date or a deadline, so parties can anticipate the duration, and that might be around 4 months from the moment the file is given to the arbitrators. But that's, again, at the moment subject to the review. And the second and final point is that if the aim is to resolve the dispute with expediency, yet with complete respect of due process, of course, arbitrators may want to consider making use of their powers of summary dismissal and early determination alongside expedited proceedings when the rules allow for that, in order to simplify the case and therefore being able to pay more attention to those issues that are really problematic in the context of expedited proceedings. So all in all, a hands-on approach where the arbitrator plays indeed a relevant protagonist role and the parties need to collaborate alongside the arbitrators. Thank you.
Thank you, Manuel. Kim Beng, can I invite you to make some quick observations on other directions that you've seen expedited arbitrators, or indeed you as an arbitrator might have made in expedited procedure arbitrations?
Sure, Lawrence. One point perhaps is to share my experience sitting as an expedited arbitrator, what I find to be a useful case management tool, which is actually to set comprehensive directions as early as possible, really right from the outset of the expedited procedure arbitration. I found that it tends to be easier to get parties to agree on those comprehensive directions at the outset, rather than have to address these issues and request for certain directions as we get further along the expedited procedure arbitration. Because obviously at a point, if you've burned 2 months out of the 6 months, one party is going to be antsy about whether they're going to get the direction or not, and that somehow tends to be more contentious. And practically what I like to do is, knowing that it's a 6-month process for the expedited arbitration, and as we've heard from Manuel, that includes the scrutiny by the institution, which is a real benefit enjoyed by users of SIAC and MIAC arbitration. My preference is actually to set aside the last month of the 6 months for preparing the award and for the scrutiny process leading to the handing down of the final award. And so we work backwards from there, and we build in the interim stages from month 1. So that's one thing I like to do right from the outset of the arbitration. The other thing to think about perhaps is, instead of going by the pleading style approach, it is to consider the memorial style approach, where you then have the pleadings or the submissions combined with the evidence instead of doing it in series. If done in an efficient way, you might actually condense the process to a 3-step process instead of a 5-step process, for example, because in pleadings, you sometimes go through up to 4 rounds with the reply to defense to counterclaim or even a rejoinder. Whereas if you have the memorial style approach, you might start with the first round exchange of the statement of claim and the defense, and then interpose with a short discovery in between, and conclude with the 3rd step of a final exchange of submissions and witness statements. And there you go, you can have the hearing followed by the award. So these are just some case management tools that I've deployed in my experience as an expedited procedure arbitrator, which I found effective and useful. Thank you, Lauren.
Thanks, Kim Beng. Victor, Joy mentioned earlier on that in relative to what might normally be a 100-page award, an award emerging from expedited procedure arbitration in summary form might take 30 to 50 pages. I'd like to ask you to what extent parties can expect the length of MIAC expedited procedure awards. Is there some sort of objective measurement, or would it depend from arbitrator to arbitrator and his or her background?
Sure. Thank you for the questions, Lawrence. I wouldn't think there is a specific length for the award, but when you could look at the MIAC rules, where you can really see the spirit, it is to limit as much as possible all interference by the parties and the actuations of the arbitrator. So I couldn't be able to give you a specific number of pages, but it is the spirit that you were mentioning. It has to be short because the own nature of the proceeding, it is in line what the award should be. And just to comment on some of the directions that can lead in expedited procedures, I just wanted to mention as well some of the scenarios that I've seen as a counsel. We, because even though efficiency is a key element of arbitration, especially in expedited procedures, it is true that this constant intent of speed up things sometimes lead to a difficult situation to be handled by the arbitrators. And we often find cases where the parties request the examination of experts or witness testimonies, even though the hearing is not going to be held. So the panel is going to have to be able to propose a suitable alternative to the practice to present their case. It is nowadays also very common to see arbitrators requesting the parties for further justifications for the need to hear witnesses or experts, or even the relevance of them at all for the case. So as a counsel, you can find yourself having to justify all the evidence you propose. So just having in mind the nature of the procedure, you should be acting considering the higher chances of having this evidence you propose declined by the panel compared to an ordinary arbitration proceeding. In situations like this, from a counsel point of view, I think it's going to be vital to carefully analyze what are the key evidence for your case, how is the best way to produce this evidence, everything beforehand, and also in what order we propose them to be produced, always looking at maximizing the positive impact to your case. Or the other scenario we see in these in EP cases is that the documentary disclosure is very limited or even eliminated by the panel to avoid consuming excessive time. And this is critical, especially if we look at it from a common law lawyer perspective, because of for obvious reasons, but the main one is the tendency you have to rely on the mechanism because of the similarities with the ordinary litigation in common law jurisdiction. And I really pay attention to this because you may even find yourself without the possibility of requesting those documents from the other parties. Maybe you created a case strategy around that. So that is another point I could really take into account. And the last one with regard to the hearing, it is nowadays very common to see arbitrators limiting the general time of the hearing, but as well as Manuel was mentioning, to use the chess clock system, which happily serve as or leave us the organization of the time as we see fit. And if that tool is important in ordinary arbitration cases, in this one is much more useful because you get to maximize the resources and organize the evidence in the way you want. That could be all, but I think it is really hard to provide general guidance about how to manage this type of situations from an arbitrator point of view because of the many and different circumstances that may arise. So it has to be analyzed on a case-by-case basis. So I get back to you, Lawrence.
Let's move on now to more complex and difficult questions, but Before I do, I'd like to remind members of the audience that there is a question and answer function to this event, which you can activate at the bottom of your screen. So if you do have questions for our audience, for our panel, please do send it across and we will consider them. Turning now to the next part of the webinar, operating an expedited procedure may sometimes involve a tension between a contractual duty to act expeditiously and the right of parties to have a full and equal basis to present their cases and test each other's cases. Preferably, as you've heard one of our panelists say, these issues are considered or should be considered at the initial procedural meeting. Kim Beng, you mentioned this a little bit earlier, but do you see that difficulties may arise when one party insists that there should be an elaborate procedure for further submissions or disclosure of documents?
Thank you, Lawrence. Certainly, I mean, if you have a party with expectation or a requirement of an elaborate procedure for disclosure of documents or for argument and submission, that would place a significant strain on the time that one has for the expedited procedure process. And that's why a couple of things I think go into that. One is having an arbitrator steering the process who's perhaps got enough experience and a strategic sense on how to approach such issues. What I mean to say is, if knowing that there could be a party with such an expectation, then I think it's important that these aims are identified early and an opportunity given to the parties to ventilate the reasons as to why certain procedures are being sought, directions are being sought, and that these requests are properly addressed. And finally, the arbitrator making a decision as to what is the most effective and efficient way to have a fair hearing, respecting as far as possible the desires and aims of the parties. Again, I go back to the case management tool I mentioned earlier about having these addressed comprehensively as early as possible in perhaps the initial case management conference. The other thing to be mindful of is something that Joy has alluded to. She foreshadowed it earlier when we were discussing the earlier topic, that in these directions, the arbitrator might want to place strict timelines for certain applications to be made, or even guillotines, if you like, that once a certain time is passed, then the opportunity to raise certain issues or to make certain types of applications would be foregone. I think those are suggestions that might make the process balanced and fair and also efficient. And importantly, at all times, parties, it would be difficult for any particular party to say that they've not had a chance to present their case, whether it's substantively or a certain procedure that they feel is necessary for the process. I think finally, Lawrence, the point I would add is that the SIAC rules helpfully has a Rule 5.4 that allows the arbitrator, in consultation with the registrar of the SIAC, upon the application by either party, to determine that the arbitration should no longer be conducted in accordance with the expedited procedure. Now, this sometimes happens. This happened in expedited procedure arbitrations that I've sat in as arbitrator, where new claims are introduced midstream, new evidence is introduced, and it really just changes the complexion of the case. So if one recalls the criteria that we talked about earlier, the three criteria, essentially are looking at a situation where a new factor is added that takes the arbitration outside that qualifying criteria. And what 5.4 affords is the flexibility to then go out of the expedited procedure track into a more conventional arbitration process. Thank you, Lawrence.
Thanks. Victor, what about situations where one party insists not only on substantial witness statements, but that there should be an oral hearing where all witnesses, big and small, are cross-examined, and also that there should be several rounds of legal submissions? What would you imagine would happen to an expedited procedure arbitration in this kind of situation?
Well, being that a difficult situation for the arbitrator in any case, we cannot forget that the arbitrators have the power to limit the evidence presented by the parties. In line with what Manuel was saying at the beginning, I think they have to be confident in the powers that the rules give them, because at the end of the day, the parties chose those rules. And indeed, some of the arbitration rules of international centers, as it is the case of MIAC and SIAC, allow the arbitrators to shorten any of the time limits provided in their own rules. But to give you an answer, put it in practical terms, I think that the way a situation of this nature should be managed, or it is likely to be managed, depends a lot on when it happens and how the proceedings have been conducted so far. So if this occurs at the beginning of the proceedings, with the term of reference hasn't even been elaborated, it is still a good time to address this request, because it is precisely the time when the proceedings must be organized. And if there is a case in which we have this, we're not going to call it excessive request, but multiples at least, the arbitrators feel that it is impossible to allow them in a proceeding like this, or it is simply incompatible. I think it's a good moment to reconsider or see the possibility of move the proceedings to an ordinary procedure. It is time to evaluate if this should be done or could be done. And in the case situations like this arise in the middle of the proceeding, I think it's going to be very important that the arbitrators had been absolutely clear about the most important elements of the proceeding, such as deadlines, extensions of the submissions, whether the hearing is going to be held or not, how the arbitrators would like the evidence to be presented, and even reminding them of the pace of the procedure due to its own nature, that some of them tend to forget. For these type of situations, I tend to prefer to have a written term of reference, which can include in detail all the main elements of the proceeding, especially regarding the takings of evidence, because it is a very important tool for the arbitrators to be reminding the parties of what they really agreed on in the beginning. But in case the arbitrator has done its job properly and said requests were not contemplated in the terms of reference, I would be inclined to reject them, at least partially, because we all know that the wills of the parties is a key element. But at the same time, we cannot forget that this excessive requests sometimes are only part of an obstructive strategy, but led by a council. And it is important that arbitrators guarantee that the due process for both parties, or the multiple parties there is. But to me, it is also important to avoid acting led by this due process obsession sometimes, because this overprotection sometimes lead to the nature of the proceedings, and in some instances to an unfair treatment to the other parties. So that could be all for my part.
Thank you, Victor. Joy, when issues of more elaborate proceedings or procedures arise midway, have tribunals tended to indulge the parties and considered an extension of time for the expedited procedure, or have they been more strict and compelled the parties to come in within the standard timeline?
Thanks, Lawrence. So as Kim Bing was explaining at the tail end of his remarks, under the SIAC rules, the tribunals do have the option to, take the arbitration off the EP track, sort of to unexpedite the procedure, as you were, right? Under Rule 5.4. upon the application of a party, right? And you know, often there is a legitimate basis for this kind of unexpedition, as Kim Beng mentioned also, right? I mean, at the first stage, the president grants the EP based on initial submissions, but you know, occasionally after the full submissions come in, and you say, you know, the respondent files a very substantial counterclaim together with the statement of defense, or, you know, the number of witnesses from each party, you know, suddenly exceeds the initial expectation, or, you know, halfway through there is this suddenly a jurisdictional challenge or an extensive sort of document production fight, right? In such situations, it could be that the case, it becomes clear to the arbitrator that this is, you know, this is not a case that's suitable for determination under the expedited procedure, right? And those would be cases where the tribunal should properly consider invoking Rule 5.4. However, in practice, tribunals do have another option other than to just avail themselves of 5.4. That is to request a short extension of time, say for no more than a couple of months, you know, from the registrar to extend the time and the deadline under the SIAC Rule 5.2, right? As we know, 5.2D does provide that such an extension of time may only be granted in exceptional circumstances. I will say that in practice, you know, if you look at the added complexity of the case, and if you've got parties' agreement for an extension, these two factors are occasionally, often considered sufficient to satisfy that exceptional circumstances requirement, right? So if arbitrators avail themselves of this option, it does give them some flexibility to, you know, keep the arbitration still under the EP track and complete it within, you know, a relatively shorter time frame than your normal track arbitration, right? And we've got statistics in that regard, and SIAC does sterling work in terms of managing the time for, you know, normal track arbitration. But, you know, with the best will in the world, you're still looking at a time frame that could easily take more than a year, right? So if you've got this, I suppose, extended EP type of option and procedure, that, you know, would still afford a more efficient outcome than the normal procedure, right? And in my view, it's for this reason that tribunals here in Singapore do occasionally tend to indulge parties, I guess, Lawrence, to take your to use your term, and extend time rather than to, you know, unexpedite pursuant to 5.4. And of course, these remarks are premised on the premise that this is a genuine case where parties are genuinely looking at a real need to extend time, as opposed to, as Victor was mentioning, just sort of some procedural gambit by counsel who want to drag things out, right? But assuming, you know, we do have the situation where something does legitimately come up and there is a legitimate request for more time to deal with these matters, I did think that a good way of dealing with it and keeping still to the efficiency was to look to extend time as is requested under these sorts of circumstances. Thanks, Lawrence.
Manuel, there may be occasions where the proceedings develop to a point where the tribunal is asked to consider whether expedited proceedings and the expedited procedure should no longer apply to the proceedings. When do you imagine that a tribunal would reach that kind of conclusion and decide that the expedited procedure should no longer apply?
Thank you, Lawrence. So Kim Beng and Joy have already made it very clear that under Rule 5.4 of the SIAC rules, the tribunal has the power, in light of the circumstances and in consultation with the registrar, to mutate the proceedings from expedited to ordinary proceedings. And that's just a demonstration that arbitration is dynamic and things don't develop just as set in stone in procedure order number 1, and the institution and the arbitrators need to be adaptive to that development. Now, one of the circumstances where these issues may arise is when the amount in dispute may change during the proceedings. And that can be for 2 reasons, at least in my experience. One, as Kim Beng just mentioned, is when a new claim is introduced or a new counterclaim is introduced, in which case the amount in dispute can exceed the threshold set for expedited proceedings. Another type of situation which impacts the amount, and that was my experience in one recent case, is when the institution decides that the very same claims that were brought in the beginning should be quantified differently. In that case, there were two primary claims. One was for breach of contract, payment of an outstanding amount of, let's say, around 100,000 euros. But together with that was a larger claim for just a specific performance of the remaining part of the contract. Now, the institution had not used that second leg to quantify the amount in dispute, even though the outstanding amount of the contract for future purposes was on the millions. And therefore they decided, just looking at the first leg of the claim, to quantify it as under the threshold of expedited proceedings. Now, when the institution then changed the approach at the request of one of the parties, they decided that the amount should be increased, and therefore that clearly had an impact on the fees that the institution could receive, the fees that the arbitrators would receive. However, they decided that that will not alter the nature of the proceedings. That is, that would not mutate the proceedings from abbreviated or expedited to ordinary. And the reason for this was to avoid the procedural dysfunctions that could follow from that alteration. And in that sense, it's very positive that the rules in SIAC say that despite that mutation of proceedings, that will not alter the number of arbitrators or the constitution of the tribunal that has been appointed at the start of the proceedings. That is, we are not moving, at least at my reading of SIAC rules, from 1-member tribunal to suddenly appointment of 2 more members for the tribunal, because understandably that would cause a major disruption to the process. And that was precisely what the Madrid institution was trying to avoid when that situation arose in the case I mentioned before. Now, at the moment, MIAC rules do not provide for a rule equivalent to Rule 5.4, and my understanding of, and certainly I'm not speaking for MIAC, but my understanding as user of MIAC rules is that at the moment, proceedings cannot be changed from expedited to ordinary, even when an amount has increased. However, also my understanding is that that rule is subject to review, with the option of giving arbitrators, not the institution, but arbitrators, alongside what Rule 5.4 of SIAC provides, the exceptional power to adopt the transformation of the proceedings, which is exactly what I think it will be appropriate in cases like the one I have mentioned. Now, something that it does not happen very frequently is when proceedings start in an ordinary fashion, and the question arises whether they should then be moved to an expedited proceeding fashion. And that's the opposite way. And that may happen, for instance, when the arbitrators dispose of some of the claims in a summary form or through early dismissal because they are unmeritorious claims. In that case, it might be that the case suddenly becomes quite simple. The amount, it becomes lower than originally. So a legitimate point in order to facilitate the resolution of the dispute in an expedient and not very expensive way would be to simplify and shorten the proceedings. Again, that might not mean reducing the existing 3-member panel to 1-member tribunal. That would not probably be very disruptive. We could continue having 3 arbitrators, but still the timeline of the proceedings could be revisited precisely to reflect the simplification after some decisions or some withdrawals or some waivers of claims, or one party has been absent and has decided not to defend the case. There are many circumstances. And what all in all this reflects is that, again, tribunals and institutions really want to be adaptive and to tailor the proceedings to the circumstances of the case. And I think a positive development might be that the institutions even consider super abbreviated or expedited proceedings, proceedings which cater for needs of disputes which are not very substantial, maybe around 150 to 100,000, even half a million in some instances, which could be resolved within a month or a month and a half. I believe that some institutions have looked into that, and my understanding is that MIAC, again, wants to take the lead on that move because, again, it serves the needs of the market in a better way. Thank you, Lawrence.
Manuel, I'm very glad that you gave us, you pointed to us that expedited procedure could be considered midway through ordinary proceedings, because I'm going to ask the panel, if I may, a little bit more on this area and this tension between expedited procedure and the right to a full and fair hearing. We start off with an arbitration agreement where the usual analysis from the common law perspective is that it is implied that by selecting a particular set of rules that the parties intend for their arbitral procedures to be abbreviated, and if necessary, steps even omitted. If certain conditions are satisfied, from a civil law point of view, perhaps the analysis would be that a good faith application of the terms of the arbitration agreement entail an abbreviation of timelines and possibly an omission of steps. But equally, the analysis on an arbitration agreement would be that the parties are to be taken toward equal treatment and a full opportunity of presenting their case. Indeed, the law of the seat of the arbitral proceedings, particularly if they are UNCITRAL model law countries, would guarantee that. Where would each of you say is that middle ground between what the parties have agreed by adopting rules that contain expedited procedures, and the other hand, where the parties are also taken to have agreed that they would be guaranteed equal treatment and a full opportunity of presenting their case? I mean, in a situation where one party says, I need more disclosure, more witness statements, an oral hearing, more submissions, and the other party says, no, we must adhere to the agreed expedited procedure. What for you, for each of you, would be not necessarily the deciding factor, but the measure by which you would assess the position of the parties? Not an easy question to answer, but perhaps let's see what each of our panelists say, starting with Kim Beng, perhaps.
That's an interesting poser, Lawrence. I would say that scenario probably engages the different features that we've heard from my colleagues on the panel. What I mean is a set of comprehensive directions that covers the entirety of the procedure and is scheduled to take place over the 6-month duration that is allowed for the expedited procedure process. And also to then have the flexibility to request an extension of time if necessary, if there are new developments or new discoveries or new issues that arise that warrant or engender that sort of a slight adjustment to the EP timescale. And finally, possibly invoking 5.4 of the SIAC rules to unexpedite the expedited procedure. I don't think we can prescribe a certain particular algorithm that decides when the line is crossed. I do think that, again, I go back to my earlier point about the the benefit of having perhaps an arbitrator that's got some experience in this area to be able to recognize when the considerations have changed and that the circumstances underlying the changed circumstances are legitimate, that would warrant shifting away from the EP process. That's my attempt at trying to answer your question. Perhaps I'll invite my fellow panelists to chime in now.
Victor, any views?
Sure. Well, as King was saying, it is not an easy question because there is a big or an ample gray area there, and it is based on the preferences of the users. And I think this leads precisely to the regulations we are seeing in some of the rules that are regulating when there is a conflict between the arbitration agreement and the rules. And they are also divided in that because you have to cut one of the legs, and the two legs are very important. So I think I will, and this is really connected with what Manuel was saying, I will always be, and this goes in contrast what I said before, but we have to protect to the extent possible that the users have the possibility of accommodating the process, because at the end of the day, this works because people trust in that there is going to be a center and there are going to be arbitrators that we are able to adapt the proceedings to their needs. The problem here is that we have to not only take into considerations the rights to present their case. The problem here is the use that we can do based on that. There are many ways to be putting pressure on the arbitrator with some gray allegations that there are violations of due process, and it is a really gray area. And I think this is also very jurisdiction-wise thoughts. I think it's not going to be seen. I think we are not going to be agreeing on something very solid if we compare different jurisdictions. It is a difficult questions to concise elements that are key to the arbitration proceedings.
Joy, what about you?
Yeah, so I mean, everything that we've been talking about that the expedited procedure seeks to solve for, right? That comes down to efficacy, essentially, when you sort of compare it against the needs of the case, right? I mean, the need to ensure efficacy, the need for robust case management, the need to ensure that matters are decided in a sufficiently expeditious way that does justice to the parties. I mean, those things should apply to the entire swathe of arbitration, right? Not just expedited procedure. I guess the balance, of course, there is that if you've got a relatively less complex claim and a claim that is, again, relatively less high in value, the sort of default position is to aim yourself towards efficacy, right? Shorter timelines, less complex measures, shorter awards, etc. Whereas I suppose if you are normal track arbitration, again, I suppose the default is to allow for more indulgence of parties and longer timelines and more submissions and I guess longer page limits, right? And I think that that's probably the right balance, to be struck. Of course, the touchstone for both, I guess, counsel as well as arbitrators must be that efficacy is fine and well. SIAC and MIAC do a sterling job in ensuring that. But at the end of the day, natural justice must not be sacrificed in the name of efficacy. So obviously that is, I think, the touchstone that we all need to adhere to. And I think that's probably the principle that underlies, I will say, my own approach to these matters.
Manuel, we come back to you. Joy has said that natural justice or full opportunity to be heard must not be sacrificed, but the parties have agreed a more efficient process.
Sure, and I believe it is precisely that agreement that saves arbitrators and institutions when one party, because it's usually one party rather than both of them, wants to derail or wants to transform the proceedings to something different to what the parties agreed. Certainly neither institutions nor arbitrators want to have an award set aside. Requests for setting aside happen and they go beyond the control of what the arbitrator might be able to control, but the reputational impact of having an actual annulment is something that you want to avoid. But simultaneously, the whole proceeding cannot be at the mercy of one of the parties, and therefore the tribunals being constantly granting extensions and applications. And in that sense, that's why I said in the beginning that drafting that procedure order number 1, those terms of reference at the earliest stage, and relying on what parties knew or should have known at the time when that PO1 was issued, when parties were able to give comments on the draft form of that PO1, so that they are indirectly even waiving their right to object if something that should have been known at that stage was not raised. That's certainly a very good protective way from the arbitrator. I also try to emphasize the need by the arbitrator to explain what he or she is doing and why he or she is doing it, how they are trying to protect the rights of the parties, regardless of the objections that then have to be sometimes dismissed with reasons. But the award is a very good opportunity, and PO 2, 3, 4, 5, 17, whatever, are very good opportunities for the arbitrators to explain how they are trying to cater for the rights review process. And in my experience, that was something that has been valued and useful. Now, on whether abbreviated proceedings or expedited proceedings offer that balance between due process and expedited decision, and I was lucky to attend a couple of sessions at UNCITRAL on the expedited arbitration rules. And it was indeed interesting to see how some very well-known voices were arguing that expedited arbitration should be the default option, with ordinary arbitration only applying when arbitration becomes excessively complex or excessively significant in volume. But if you want a middle ground, that means that you have the ordinary arbitration at the top end, but also you need a maybe hyper abbreviated or hyper expedited arbitration, so that abbreviated is indeed in the middle of the two options. And in that sense, I believe it's interesting that institutions are considering this even more abbreviated way.
Interesting thought that ordinary becomes extraordinary. In the last few minutes of our event today, I thought I'd deal with some of the common questions that SIAC is asked, and no doubt there would be interest to know the position at MIAC as well. So let me start with Victor and ask whether the monetary limits in the case of MIAC, euro 1 million, are they hard and fast limits in a sense that if a party's claim is just over euro 1 million, is there the opportunity for expedited procedure to apply or not to apply? And what if the claim is expressed in a foreign currency? Victor?
Yes. Well, the information that the center provides it is a hard quantum, but we also have to take into account that the eventual counterclaims are not known at the moment when they are evaluating this amount. But it is in general a hard quantum to be followed. This is I like the question because it is interesting to see the MIAC has set it up in €1 million, but compared it to other rules, it is interesting to see that the big variation compared, for example, with the SIAC or ICC is 3 million, and this has a great impact on how many cases you attract to apply directly the expedited procedures. The lower the amount is, the more cases you're gonna avoid to have this direct application in cases as the MIAC that adopted an Untitled approach. But it is a hard amount. Yeah.
Joy, would the position be similar in SIAC in your understanding?
Yeah, to my understanding, the $6 million cap, it's a hard cap, right? As Kim Beng was saying, it's the aggregate. So you need to add up the value of the claim plus the value of the counterclaim, and you take on board also any defense or set off, etc., including interest, right? It's a hard cap. If you're not there, then you're not an EP track. I'm afraid, right?
Manuel, not an easy question again, but what happens if a party does not state a value to its claim, but yet applies for expedited procedure? What happens in MIAC?
Right. Thank you for that easy question. I'm afraid I don't speak on behalf of MIAC, and I'm not aware of any case where that has been faced with me, at least with my direct involvement professionally. I believe if in those cases there is no quantification, therefore probably the expedited proceeding is not available. But as I said, I'm speaking in a personal capacity and from in my own opinion. What I know is that when the claim uses a foreign currency, the relevant time is when the request for arbitration is submitted in terms of calculating the rate of exchange that is applicable to decide on the threshold.
Kim Beng, would the position be any different in SIAC in your understanding?
My understanding is similar to what Manuel has shared. I think certainly if the quantum is not stated there, it would give some pause or reservation as to whether it's arbitration that should go on an EP procedure. Although, in my experience, there's usually a bit of toing and froing to try and get the parties to at least state an amount, even if it's just an estimate, where the placeholder that they put in is to say damages to be assessed. So hopefully in that process, there may be some quantum that's distilled. But if nothing is produced, then I think it's going to make it tough.
Ladies and gentlemen, I hope you enjoyed our event today and the excellent contributions from our panelists. It remains for me to thank you for your time in attending this event and to hand over proceedings back to Sue Ann.
Thank you, Mr. Tay, and thank you to our panelists for the very engaging and insightful session. We hope you have enjoyed the session, and we hope to see you at our future SIAC events. Thank you once again for joining us today. Have a lovely day or evening ahead, everyone. Bye.